Exam 2, Lawmaking and the Law of Tort, focuses on lawmaking in England and Wales as well as the European Union. This exam covers lawmaking methods and their underpinning concepts, providing an understanding of legal method and reasoning as used by lawyers and the judiciary. The process of parliamentary lawmaking is the procedure where a proposal for new legislation or a change in existing law is formally debated and approved by Parliament before becoming an act. A bill is a draft version of a proposed law presented for discussion before Parliament. The different types of bills are public bills, private bills, and private members' bills. A public bill is one that applies to the whole country and is usually introduced by a government minister. A private bill is one that affects only a particular group, organization, or area rather than the general public. A private member's bill is one introduced by an individual MP or lord who is not part of the government. The stages of parliamentary lawmaking are green papers, white papers, first reading, second reading, committee stage, report stage, House of Lords stage, consultation stage, and royal assent. During the green paper stage, the government publishes initial proposals for discussion and invites feedback from interested parties. During the white paper stage, the government sets out its firm policy intentions based on earlier consultations. At the first reading, the bill's title and main aims are read out, and copies are made available to members without debate. At the second reading, the general principles of the bill are debated and voted on by MPs. During the committee stage, a smaller group of MPs or lords examine the bill in detail and may make amendments. At the report stage, the committee reports back to the House on the proposed changes for further consideration. During the House of Lords stage, the bill goes through the same readings and scrutiny process in the second chamber. During the consultation stage, the government seeks views from experts, stakeholders, and the public to refine the bill. At the royal assent stage, the monarch formally approves the bill, allowing it to become law. The role of the Crown in the lawmaking process is to give royal assent to bills passed by Parliament, which finalises their status as law. The advantages of the parliamentary lawmaking process are that it is democratic, thorough, and allows for wide consultation and scrutiny. The disadvantages of the parliamentary lawmaking process are that it is slow, complex, and often influenced by political pressures. Delegated legislation is law made by an individual or body other than Parliament, but with the authority of Parliament through an enabling act. The different types of delegated legislation are orders in council, statutory instruments, and bylaws. Orders in council are made by the King and the Privy Council, often in emergencies, such as the fuel crisis 1973. Statutory instruments are made by government ministers to update or enforce laws, such as the Police Codes of Practice under PACE 1984. Bylaws are made by local authorities or public corporations to regulate local matters, such as smoking bans on London Underground trains. The controls on delegated legislation are the Parent Act, the Negative Resolution Procedure, the Affirmative Resolution Procedure, and scrutiny by committee. The Parent Act sets out the framework and limits of power, as seen in the Road Traffic Act 1988. The Negative Resolution Procedure allows an instrument to become law unless rejected by Parliament within 40 days, such as the Road Vehicles Regulations. The Affirmative Resolution Procedure requires active approval by Parliament before coming into force, as used for Police and Criminal Evidence Act codes. Scrutiny by committee, such as the Joint Committee on Statutory Instruments, examines technical issues to ensure compliance with the Enabling Act. Judicial review is used in delegated legislation to challenge laws that exceed granted powers through procedural ultra vires, substantive ultra vires, or Wensbury unreasonableness. Procedural ultra vires occurs when proper procedures are not followed, as shown in Aylesbury Mushroom Case 1972. Substantive ultra vires arises when the content of the law exceeds the power given by Parliament, as seen in R.V. Home Secretary Ex Parte Fire Brigades Union 1995. Wensbury unreasonableness occurs when a decision is so unreasonable that no reasonable authority would make it, as illustrated in Associated Provincial Picture Houses v. Wensbury Corporation 1948. The reasons for the use of delegated legislation include saving parliamentary time, such as updating the national minimum wage. Delegated legislation is used to provide expert knowledge, such as health regulations under the Public Health Act. Delegated legislation is used to allow flexibility and speed in emergencies, such as during the COVID-19 pandemic. Delegated legislation is used to enable local control, such as parking restrictions by local councils. The advantages of delegated legislation are that it saves time, allows expert input, provides flexibility, and can be quickly amended. The disadvantages of delegated legislation are that it lacks parliamentary scrutiny, can be complex, risks abuse of power, and may reduce democratic accountability. Parliamentary and judicial controls are effective as they ensure laws remain within granted powers, such as in Aylesbury Mushroom Case 1972. Parliamentary and judicial controls are ineffective when scrutiny is limited or challenges are costly, as seen in R.V. Home Secretary Ex Parte Fire Brigades Union 1995. Statutory interpretation is the process where judges determine the meaning of words in legislation through established judicial methods. The different rules or approaches to statutory interpretation are the literal rule, the golden rule, the mischief rule, and the purposive approach. The literal rule is the approach where judges give words their plain meaning as shown in Whiteley v. Chappell and London and North Eastern Railway v. Berriman. The advantages of the literal rule are that it respects parliamentary supremacy and provides certainty, however the disadvantages are that it sometimes produces unjust outcomes and ignores context. The golden rule is the approach where judges modify the literal meaning to avoid absurdity as shown in Adler v. George and re Sigsworth. The advantages of the golden rule are that it prevents absurdity and promotes fairness, however the disadvantages are that it lacks clear guidance and risks judicial creativity. The mischief rule is the approach where judges examine the gap the statute aimed to remedy as shown in Hayden's case and Smith v. Hughes. The advantages of the mischief rule are that it promotes the intention of Parliament and flexible justice, however the disadvantages are that it reduces certainty and increases judicial discretion. The purposive approach is the approach where judges interpret legislation based on its broader aim as shown in Pepper v. Hart and R.V. Registrar General Ex Parte Smith. The advantages of the purposive approach are that it supports justice and modern legislative aims, however the disadvantages are that it potentially allows judges too much interpretative freedom. The different types of aids to interpretation are intrinsic aids and extrinsic aids. The different intrinsic aids to interpretation are titles, preambles, definitions, punctuation, and internal contextual clues. The title of an act is an intrinsic aid where wording signals the scope of legislation, and this was relied on in Powell v. Kempton Park Racecourse. The preamble is an intrinsic aid where judges use introductory text to understand purpose, and it guided interpretation in Hayden's case. The definition section is an intrinsic aid where statutory meanings clarify terms, and this guided the court in Fisher v. Bell. The use of punctuation is an intrinsic aid where judges rely on grammatical structure, and this was noted in Hanlon v. Law Society. Internal contextual clues are intrinsic aids where surrounding provisions guide interpretation, and this supported reasoning in Wheatley. The different extrinsic aids to interpretation are dictionaries, Hansard, law reform reports, international treaties, and previous case law. Dictionaries are extrinsic aids where judges use contemporary meanings of words, and this occurred in Vaughan v. Vaughan. Hansard is an extrinsic aid where parliamentary debates clarify intention, and this was permitted in Pepper v. Hart. Law reform reports are extrinsic aids where judges consult expert recommendations, and this was used in Black-Clawson. International treaties are extrinsic aids where judges align domestic interpretation with external obligations, and this guided reasoning in Pickstone v. Freemans. Previous case law is an extrinsic aid where courts rely on earlier judicial reasoning, and this shaped interpretation in Wheatley. The impact of European Union law on statutory interpretation is the requirement that judges interpret legislation in line with EU principles, where cases such as Marleasing and Pickstone v. Freemans demonstrate a strong purposive influence. The impact of the Human Rights Act 1998 on statutory interpretation is the obligation to interpret legislation compatibly with convention rights, where cases such as Gaydon v. Godin Mendoza and RVA show a significantly expanded purposive and rights-focused approach. Judicial precedent is a system where past judicial decisions guide future rulings to ensure consistency and certainty in the law. The doctrine of judicial precedent is the principle where courts must follow legal rules established by higher courts in earlier cases. Civil court hierarchy starts with the county court at the lowest level, followed by the High Court, then the Court of Appeal Civil Division, and finally the Supreme Court at the top. Criminal court hierarchy begins with the magistrates' courts, followed by the Crown Court, then the Court of Appeal Criminal Division, and ultimately the Supreme Court. Stare decisis is the requirement to stand by previous decisions as shown in Donoghue v. Stevenson. The civil and criminal courts relevant to stare decisis ensure that lower courts follow the legal principles set by higher courts to maintain consistency. The exceptions to the rule of stare decisis allow the Supreme Court to depart from its own decisions under Practice Directions 3 and 4 and allow the Court of Appeal to depart from its own decisions through the doctrine in Young v. Bristol Aeroplane. Practice Direction 3 allows the Supreme Court to depart from a previous decision where it is necessary to achieve justice. Practice Direction 4 allows the Supreme Court to depart from a previous decision where the law must develop to reflect modern conditions. Young v. Bristol Aeroplane allows the Court of Appeal to depart from its own decisions where there are conflicting past decisions, where a decision has been overruled by the Supreme Court, or where the previous decision was made per incurrime. The rule of ratio decidendi is the binding legal reason for a decision as demonstrated in R v. Howe. The rule of obiter dicta is a persuasive statement made by a judge that is not binding as illustrated in R v. Gotts. The different types of precedent include binding precedent, persuasive precedent, and original precedent. Binding precedent is a rule that must be followed by lower courts as shown in Donoghue v. Stevenson. Persuasive precedent is a rule that courts may follow but are not required to follow as shown in R v. Art. Original precedent is a new legal principle created where no previous precedent exists as shown in Donoghue v. Stevenson. The different methods of dealing with judicial precedent include overruling, reversing, and distinguishing earlier decisions. Overruling is where a higher court decides that a previous decision from a lower court was wrong as demonstrated in Pepper v. Hart. Reversing is where a higher court changes the decision made by a lower court in the same case as shown in Gillick v. West Norfolk. Distinguishing is where a court avoids following a precedent because the facts differ as demonstrated in Balfour v. Balfour and Merritt v. Merritt. The advantages of judicial precedent include certainty, consistency, fairness, and efficiency. The disadvantages of judicial precedent include rigidity, complexity, slow development of the law, and a dependence on chance appeals. Law reform is the process where outdated, unclear, or unfair laws are reviewed and updated to meet modern needs. The influences on Parliament are political, public opinion, media, pressure groups, lobbyists, and the Law Commission, where each can shape the laws that are proposed or passed. The political influences on Parliament are the policies and priorities of the governing party where they seek to fulfill their manifesto promises. An act that has been brought about because of political influence is the Hunting Act 2004, where the government aimed to meet electoral commitments. The advantage of political influences influencing lawmaking is that laws reflect the elected party's mandate. However, the disadvantage is that changes may prioritize political gain over public interest. Public opinion influences Parliament as widespread concerns or strong reactions from society can pressure MPs to act. An act that has been brought about because of the influence of public opinion is the Dangerous Dogs Act 1991, where rising fear about dog attacks pushed the government to legislate quickly. The advantage of public opinion influencing lawmaking is that it allows the law to respond to social attitudes. However, the disadvantage is that rapid responses may lead to poorly drafted legislation. Media influences Parliament as newspapers, television, and online platforms can highlight issues and shape public debate. An act that has been brought about because of the influence of media is the Criminal Justice Act 2003, where coverage of high-profile crimes encouraged tougher sentencing laws. The advantage of media influencing lawmaking is that it brings attention to important problems. However, the disadvantage is that sensationalism can lead to biased or rushed laws. Pressure groups influences Parliament as organised groups campaign for legal changes that support particular causes. An act that has been brought about because of the influence of pressure groups is the Equality Act 2010, where organisations promoting anti-discrimination helped shape reform. The advantage of pressure groups influencing lawmaking is that specialist knowledge improves legislation. However, the disadvantage is that groups with greater resources may dominate attention. Lobbyists influences Parliament as professional advocates promote the interests of clients and seek to persuade MPs. An act that has been brought about because of the influence of lobbyists is the Data Protection Act 2018, where industry representatives contributed to shaping regulatory standards. The advantage of lobbyists influencing lawmaking is that MPs gain expert insight. However, the disadvantage is that private interests may outweigh the wider public good. The Law Commission is an independent body reviewing and recommending legal reform and influence Parliament by producing reports and draft bills. An act that has been brought about because of the influence of Law Commission is the Consumer Rights Act 2015, where its proposals clarified and strengthened consumer protection. The Law Commission is able to reform the law by conducting research, consulting widely and presenting detailed recommendations. Some examples of law reforms by the Law Commission are changes to contract law, criminal law codification work and reforms to family law. The advantage of the Law Commission influencing lawmaking is that reforms are researched, considered and impartial. However, the disadvantage is that Parliament may ignore or delay its recommendations. European Union law is the body of rules and principles created by the EU that governs relations between its institutions, member states and individuals while shaping legal standards across the Union. The institutions of the European Union are the European Commission, the European Parliament, the Council of the European Union and the Court of Justice of the European Union. The role of the European Commission is to propose legislation, implement decisions, and manage the day-to-day business of the Union. The legal functions of the European Commission is to draft legislative proposals, enforce EU law and represent the Union on the international stage. The membership structure of the European Commission is composed of one commissioner from each member state who collectively act in the interests of the Union. The role of the European Parliament is to scrutinize EU institutions and participate in the legislative process. The legal functions of the European Parliament is to amend, approve or reject legislative proposals and oversee other EU bodies. The membership structure of the European Parliament is formed of directly elected members of the European Parliament from all member states. The role of the Council of the European Union is to coordinate policies and adopt legislation jointly with the European Parliament. The legal functions of the Council of the European Union is to negotiate and adopt laws, set budgets, and develop foreign and security policies. The membership structure of the Council of the European Union is made up of government ministers from each member state who meet in different configurations depending on the subject. The role of the Court of Justice of the European Union is to ensure that EU law is interpreted and applied equally across all member states. The legal functions of the Court of Justice of the European Union is to hear cases, give preliminary rulings and resolve disputes involving EU law. The membership structure of the Court of Justice of the European Union is built on one judge from each member state supported by advocates general. The sources of European Union law are treaties, regulations, and directives. A treaty is a foundational agreement between member states that sets out the constitutional basis and powers of the European Union. Regulations are binding legal instruments that apply automatically and uniformly in all member states. Directives are binding legal measures that require member states to achieve certain results while allowing them freedom in the method of implementation. The impact of European Union law on the law of England is that it required domestic courts to apply EU rules with priority and interpret national law consistently with European obligations. The impact of European Union law on the law of Wales is that devolved legislation had to comply with EU obligations and apply European rules as a matter of priority. The extension of rights to individuals through doctrines developed by both the CJEU and domestic courts shows that direct effect and indirect effect enabled people to rely on EU law before national courts where enforcement ensured greater legal protection. The concept of supremacy of EU law over the domestic law of member states recognizes that EU rules prevailed whenever there was conflict with national legislation. The impact on sovereignty of Parliament during the UK's membership of the European Union shows that the obligation to give priority to EU law temporarily limited Parliament's freedom to legislate contrary to European obligations. Tort law is the area of civil law that deals with wrongful acts or omissions causing harm or loss, where a remedy is provided by the courts. The aims of tort law are to compensate victims, deter wrongful behavior, uphold standards of conduct, and provide a peaceful means of resolving disputes. Tortious liability is the legal responsibility imposed on a person who commits a tort to compensate another for harm suffered. In tort law, the claimant is the person or body who brings the civil action seeking a legal remedy for harm suffered. In tort law, the defendant is the person or body accused of committing the tortious act or omission. In tort law, proof of fault is required, and the nature of the fault is usually negligence, intention, or strict liability depending on the tort. The possible defenses against tortious offences are consent, contributory negligence, volenti non fit injuria, necessity, self-defense, and statutory authority. The aim of tortious action is to restore the claimant, as far as possible, to the position they would have been in had the tort not occurred. The parties to a civil action may include any combination of both natural and legal persons, meaning individuals, companies, and organizations may act as claimants or defendants. The protected interests in tort law are personal safety, property, reputation, privacy, and economic interests. Compensation culture is the perception that people are increasingly encouraged to seek compensation for minor harm or inconvenience. The issues raised by a compensation culture are increased litigation costs, pressure on public services, defensive practices, and concerns about personal responsibility. Tort and contract is the comparison between civil liability arising independently of agreement and civil liability arising from the breach of legally binding promises. Tort and crime is the comparison between civil wrongs pursued by individuals for compensation and criminal offences prosecuted by the state for punishment. The basic differences between tort and contract and tort and crime are that tort concerns civil wrongs not based on agreement, contract concerns breaches of agreed obligations, and crime involves offences against the state punished rather than compensated. Liability is the legal responsibility of a person or organization for their actions or omissions that cause harm or loss to another. Liability in negligence is the responsibility that arises where a person breaches a duty of care and causes foreseeable harm to another. The liability in negligence for injury to people is the legal responsibility for personal injury caused by a failure to take reasonable care. The liability in negligence for damage to property is the legal responsibility for physical damage to another person's property caused by careless conduct. The potential action in negligence is a civil claim brought by a claimant seeking compensation for harm caused by the defendant's lack of reasonable care. The elements required for an action in negligence are the existence of a duty of care, a breach of that duty, and damage caused by the breach. Duty of care is a legal obligation to take reasonable care to avoid causing foreseeable harm to others. This is shown in the case of Donahue v. Stevenson, where a manufacturer was held to owe a duty of care to the ultimate consumer. The case of Donahue v. Stevenson sets out the neighbor principle, which is that a person must take reasonable care to avoid acts or omissions that can reasonably be foreseen to injure those closely and directly affected. The case of Caparo Industries v. Dickman set out the Caparo test, which is a three-stage test requiring foreseeability of damage, proximity between parties, and that it is fair, just and reasonable to impose a duty of care. The first stage of the Caparo test is foreseeability of damage, which is shown in Kent v. Griffiths where harm to the claimant was reasonably foreseeable. The second stage of the Caparo test is proximity, which is shown in McLaughlin v. O'Brien where a close relationship existed between the parties. The third stage of the Caparo test is whether it is fair, just and reasonable to impose a duty, which is shown in Hill v. Chief Constable of West Yorkshire where imposing a duty was considered inappropriate. The Caparo test is further developed in the case of Robinson v. Chief Constable of West Yorkshire, which confirms that established categories of duty should be applied before extending the law incrementally. Breach of duty is the failure to meet the required standard of care expected in the circumstances. This is shown in the case of Blythe v. Birmingham Waterworks, where a breach was defined as failing to do what a reasonable person would do. The objective standard of care and the reasonable man is the standard expected of an ordinary, prudent person, as shown in Nettleship v. Weston. Risk factors are considerations such as likelihood and seriousness of harm that affect the standard of care, as shown in Bolton v. Stone. Damage is harm or loss suffered by the claimant that is recognized by law. This is shown in the case of Rothwell v. Chemical and Insulating Co., where mere risk of harm was held insufficient. Factual causation is the requirement to show that the damage would not have occurred but for the defendant's breach, as shown in Barnett v. Chelsea and Kensington Hospital. Legal causation is the requirement that the damage is not too remote from the breach, as shown in the Wagon Mound. The relevance of any actionable defense is that a valid defense such as contributory negligence may reduce or defeat liability, as shown in Froome v. Butcher. Appreciate the burden and standard of proof is the requirement that the claimant proves their case on the balance of probabilities, as shown in Miller v. Minister of Pensions. The role of compensation in the form of damages is to place the claimant, as far as money can, in the position they would have been in had the tort not occurred, as shown in Livingston v. Raw Yards Coal Company. Occupiers' liability is the area of tort law that governs the duty of care owed by occupiers of premises to people who enter those premises and suffer injury or damage. The elements of occupiers' liability are the existence of an occupier, the presence of a danger on the premises, and damage caused by that danger. The existence of an occupier means a person with sufficient control over premises to make them responsible for safety, as shown in Wheat v. Laken, where both the brewery and the manager were occupiers. The presence of a danger on the premises means a state of the premises or something done or omitted there that creates a risk, as shown in Ward v. Tesco stores, where a slippery floor was a danger. Damage caused by that danger requires a causal link between the danger and the injury suffered, as shown in Jolly v. Sutton LBC, where foreseeable injury arose from a dangerous object. The Occupiers Liability Act 1957 sets out liability for lawful visitors, and the elements of this are the status of the visitor as lawful, the existence of a danger due to the state of the premises, and a breach of the common duty of care. The visitor must be lawful, meaning they have express or implied permission to be on the premises, as shown in Lowry v. Walker, where habitual use created implied permission. A danger due to the state of the premises includes physical features or hazards, as shown in Glasgow Corporation v. Taylor, where poisonous berries created a danger. A breach of the common duty of care occurs where the occupier fails to take reasonable care to keep visitors reasonably safe, as shown in Latimer v. AEC, where reasonable precautions were sufficient. The defenses for occupiers' liability for lawful visitors are warnings, consent, and exclusion or limitation of liability. A warning can be a defense if it is sufficient to make the visitor reasonably safe, as shown in Ray v. Mars, where a clear warning reduced liability. Consent is a defense where the visitor willingly accepts the risk, as shown in Sims v. Lee Rugby Football Club, where the claimant accepted inherent risks. Exclusion or limitation of liability can be a defense subject to statutory control, as shown in White v. Blackmore, where liability was successfully excluded. The Occupiers Liability Act 1984 sets out liability for trespassers, and the elements of this are awareness of the danger, knowledge of the trespasser's presence, and the reasonableness of offering protection. A trespasser is a person who enters premises without permission or exceeds the scope of any permission given, as shown in the case of the Calgarth. The occupier must be aware of the danger or have reasonable grounds to believe it exists, as shown in Reville v. Newbury, where a known risk was present. The occupier must know or have reasonable grounds to believe that a trespasser is in the vicinity of the danger, as shown in British Railways Board v. Harrington, where frequent trespass was known. It must be reasonable in all the circumstances to expect the occupier to offer protection, as shown in Tomlinson v. Congleton Borough Council, where it was not reasonable to protect against obvious risks. The defenses for occupiers' liability for trespassers are warnings, the obviousness of the risk, and voluntary acceptance of risk. A warning may be a defense if it gives adequate notice of the danger, as shown in Westwood v. Post Office, where warnings reduced liability. An obvious risk can be a defense where the danger is clear and apparent, as shown in Tomlinson v. Congleton Borough Council, where the risk was obvious. Voluntary acceptance of risk applies where the trespasser knowingly accepts the danger, as shown in Ratcliffe v. McConnell, where the claimant accepted a clear risk. The torts connected to land are private nuisance and Rylands v. Fletcher, both of which protect landowners from unlawful interference with the use or enjoyment of land. Private nuisance is a tort that protects a person's interest in land by preventing substantial and unreasonable interference with the use or enjoyment of that land. The elements of private nuisance are an interference with land, the interference being unreasonable, and the claimant having a proprietary interest in the land. A nuisance is interference such as noise, smells, vibrations or fumes affecting land, as shown in St. Helens Smelting Co. v. Tipping. Interference with land is an act or state of affairs that affects the claimant's use or enjoyment of land, as shown in St. Helens Smelting Co. v. Tipping. Unreasonable interference is interference that goes beyond what a reasonable neighbor should tolerate, as shown in Miller v. Jackson. Unreasonableness is assessed using factors such as locality, duration, and intensity, as shown in Miller v. Jackson. Proprietary interest is the requirement that the claimant has a legal interest in the land, as shown in Hunter v. Canary Wharf. The ability to claim is limited to those with a proprietary interest in the land, as shown in Hunter v. Canary Wharf. Liability to be sued applies to the person responsible for creating or continuing the nuisance, as shown in Sedley Denfield v. Callahan. Defenses are statutory authority and prescription. Statutory authority is a defense where the nuisance is an inevitable result of an activity authorized by Parliament, as shown in Allen v. Gulf Oil Refining Limited, while prescription is a defense where the defendant has carried out the nuisance openly and continuously for at least 20 years, as shown in Sturgis v. Bridgman. Remedies are damages, injunctions or abatement, as shown in Shelfer v. City of London Electric Lighting Company. Damages are a monetary award to compensate the claimant for loss suffered, injunctions are court orders requiring the nuisance to stop or be limited, and abatement is the self-help remedy where the claimant takes reasonable steps to remove the nuisance, as shown in Lemon v. Webb. Rylands v. Fletcher is a tort imposing strict liability where a defendant brings something dangerous onto land that escapes and causes damage. The elements of Rylands v. Fletcher are a non-natural use of land, the accumulation of a dangerous thing, escape, and damage. A non-natural use of land is a special use bringing increased danger to others, as shown in Transco plc v. Stockport Metropolitan Borough Council. Accumulation of a dangerous thing is the bringing onto land something likely to cause mischief if it escapes, as shown in Cambridge Water Co. v. Eastern Counties Leather. Escape is the movement of the dangerous thing from the defendant's land to the claimant's land, as shown in Red v. J. Lyons. Damage is foreseeable damage caused by the escape, as shown in Cambridge Water Co. v. Eastern Counties Leather. The requirements to bring a claim are that all elements of Rylands v. Fletcher are satisfied and damage is foreseeable, as shown in Cambridge Water Co. v. Eastern Counties Leather. Defenses are act of God, act of a stranger, consent and statutory authority, as shown in Nichols v. Marsland. Vicarious liability is a form of secondary liability where one party is held legally responsible for the torts committed by another. The nature of vicarious liability is strict liability, meaning fault does not need to be proven against the defendant who is held liable. The purpose of vicarious liability is to ensure victims are compensated, to spread risk fairly, and to encourage responsible organization and supervision. The elements of vicarious liability are a qualifying relationship between the parties and a tort committed in the course of that relationship. The first element is the existence of a qualifying relationship, meaning the tortfeasor must be an employee or in a relationship akin to employment, as shown in Catholic Child Welfare Society v. Various Claimants. The second element is that the tort must be committed in the course of employment, meaning there is a sufficient connection between the wrongdoing and the work, as shown in Lister v. Hesley Hall Limited. There are many tests for vicarious liability to determine whether the tortfeasor is an employee and was acting in the course of their employment. The traditional tests to determine whether the tortfeasor is an employee are the control test, the organization test, and the multiple or economic reality test. The control test examines whether the employer has the right to control how the work is done, with Ewens v. Noakes showing that extensive control suggests employment. The organization test considers whether the worker is integrated into the employer's business rather than merely an accessory, as shown in Stevenson, Jordan and Harrison Limited v. McDonald and Evans. The multiple or economic reality test looks at several factors including control, mutuality of obligation, and financial risk, with Ready Mixed Concrete Limited v. Minister of Pensions demonstrating its application. Akin to employment means a relationship that is not a formal contract of employment but is sufficiently similar to justify imposing vicarious liability. The akin to employment tests are whether the work is integral to the business, whether the activity creates risk, whether the tortfeasor is under the control of the defendant, and whether the defendant benefits from the activity. The first test is whether the activity is an integral part of the defendant's business, as shown in Cox v. Ministry of Justice where prisoners work furthered prison operations. The second test is whether the defendant created the risk by assigning the activity, demonstrated in Catholic Child Welfare Society v. Various Claimants. The third test is whether the tortfeasor is under the control of the defendant even if limited, as shown in Cox v. Ministry of Justice. The fourth test is whether the defendant is more able to compensate the victim, reinforcing liability as seen in Various Claimants v. Barclays Bank plc. The tests to determine whether the tort was committed in the course of employment are the Salmon test and the close connection test. The Salmon test is a test to determine whether a tort was committed in the course of employment by asking whether it was authorized or a wrongful mode of doing an authorized act. The elements of the salmon test are an authorized act and an unauthorized mode of carrying out an authorized act. An authorized act occurs where the employee does exactly what they are employed to do, even if it causes harm, as shown in Century Insurance v Northern Ireland Transport Board. An unauthorized mode occurs where the employee performs an authorized task in a wrongful way, as demonstrated in Limpus v London General Omnibus Company. The close connection test asks whether the tort is so closely connected to employment that it is fair and just to impose liability, as shown in Lister v Hesley Hall Limited. The liability for torts closely connected to employment is imposed where the employee's position significantly increased the risk of the tort occurring, as illustrated in Mohammed v W.M. Morrison Supermarkets plc. The new approaches when dealing with tortfeasors who do not fit the classic employer-employee relationship focus on risk creation, fairness, and business integration, allowing liability to be imposed in relationships akin to employment as developed in cases such as Cox v Ministry of Justice and various claimants v Barclays Bank plc. The defenses in tort law are legal principles that allow a defendant to reduce or avoid liability where the claimant's own conduct, consent, or other recognized factors justify limiting responsibility. The defenses in tort law are contributory negligence and volenti non fit injuria. Contributory negligence is where the claimant has failed to take reasonable care for their own safety and this failure contributed to the damage suffered. The elements of contributory negligence are a lack of reasonable care by the claimant and a causal link between that lack of care and the damage. The lack of reasonable care element requires the claimant to fall below the standard of a reasonable person, as shown in Froome v Butcher. The causation element requires the claimant's lack of care to contribute to the harm suffered, as shown in Jones v Livox Quarries. Volenti non fit injuria is where the claimant voluntarily accepts the risk of harm and therefore cannot recover damages. The elements of volenti non fit injuria are full knowledge of the risk and voluntary consent to that risk. The knowledge element requires the claimant to have full awareness of the nature and extent of the risk, as shown in Morris v Murray. The consent element requires the claimant to freely and voluntarily accept the risk, as shown in Imperial Chemical Industries v Shatwell. The defenses for torts connected to land are legal rules that protect defendants where interference with land is justified by consent, long use, statutory authority, natural use of land, or external and unforeseeable events. The defenses available to private nuisance cases are prescription, statutory authority, consent, and contributory negligence. Prescription is a defense where the defendant has carried out the nuisance for at least 20 years without interruption, as shown in Sturgis v Bridgman. Statutory authority is a defense where the nuisance arises from activities authorized by Parliament, as shown in Allen v Gulf Oil Refining. Consent is a defense where the claimant has expressly or impliedly agreed to the nuisance, as shown in Kiddle v City Business Properties. Contributory negligence is a defense where the claimant's own lack of care contributes to the harm suffered in a nuisance claim, as shown in Sedley Denfield v O'Callaghan. The defenses available to Rylands v Fletcher cases are consent, act of God, act of a third party, default of the claimant, statutory authority, and natural use of land. Consent is a defense where the claimant has agreed to the accumulation of the dangerous thing, as shown in Peters v Prince of Wales Theatre. Act of God is a defense where the escape is caused by a natural event that is unforeseeable and extraordinary, as shown in Nichols v Marsland. Act of a third party is a defense where the escape is caused by the unforeseeable actions of an independent third party, as shown in Rickards v Lothian. Default of the claimant is a defense where the escape is wholly caused by the claimant's own actions, as shown in Ponting v Noakes. Statutory authority is a defense where the accumulation and use of the dangerous thing is authorized by statute, as shown in Green v Chelsea Waterworks. Natural use of land is a defense where the accumulation is a natural and ordinary use of the land, as shown in Transco v Stockport. Remedies are the legal responses provided by the courts to address a civil wrong and place the claimant in the position they would have been in had the tort not occurred. The remedies in tort law are compensatory damages, mitigation of loss, and injunctions. Compensatory damages are a monetary award intended to compensate the claimant for the loss suffered as a result of the defendant's tort. The elements of compensatory damages are pecuniary loss and non-pecuniary loss. Pecuniary loss is financial loss that can be calculated in monetary terms, such as loss of earnings or medical expenses, as shown in Smith v Manchester Corporation. Non-pecuniary loss is loss that cannot be precisely calculated in money, such as pain, suffering, and loss of amenity, as shown in West v. Shepherd. Mitigation of loss are the rules requiring the claimant to take reasonable steps to reduce the loss caused by the defendant's wrongdoing. The elements of mitigation of loss are the claimant's duty to mitigate and the defendant's burden of proof. The claimant's duty to mitigate means the claimant must act reasonably to limit their losses after the tort, as shown in British Westinghouse Electric v. Underground Electric Railways. The defendant's burden of proof means it is for the defendant to show that the claimant failed to take reasonable steps to mitigate their loss, as shown in Paisu v. Saunders. Injunctions are court orders requiring a defendant to do or refrain from doing a specific act to prevent ongoing or future harm. The elements of injunctions are that damages must be inadequate, the balance of convenience must favor the claimant, and the remedy is discretionary. Damages must be inadequate means that monetary compensation would not sufficiently remedy the harm, as shown in Shelfer v. City of London Electric Lighting. The balance of convenience means the court weighs the harm to both parties to decide whether granting the injunction is fair, as shown in American Cyanamid v. Ethicon. The discretionary nature of injunctions means the court is not obliged to grant them and will consider fairness and justice in each case, as shown in Miller v. Jackson. There are many benefits and drawbacks to the law of liability in negligence, occupiers' liability, and vicarious liability. An advantage of the law of liability in negligence is that it protects claimants from physical harm, as shown in Donahue v. Stevenson. Another advantage is that it allows compensation for reasonably foreseeable losses, as shown in Caparo v. Dickman. As well as this, liability in negligence also encourages higher standards of care by defendants, as shown in Nettleship v. Weston. However, a disadvantage of the law of liability in negligence is that it can be difficult for claimants to prove a duty of care, as shown in Hill v. Chief Constable of West Yorkshire. Another disadvantage is that it may limit recovery through policy considerations, as shown in Caparo v. Dickman. As well as this, liability in negligence also can deny compensation where damage is not reasonably foreseeable, as shown in Borhill v. Young. The law of liability in negligence is fair as it compensates individuals who suffer harm due to another's lack of reasonable care, which is shown in the case of Donahue v. Stevenson. However, the law of liability in negligence is unfair as it can prevent deserving claimants from succeeding due to restrictive duty rules, which is shown in the case of Hill v. Chief Constable of West Yorkshire. The law of liability in negligence balances competing interests as it protects claimants from harm while avoiding excessive liability on defendants, which is shown in the case of Caparo v. Dickman. However, it may not balance competing interests as it can prioritize public policy over individual justice, which is shown in the case of Hill v. Chief Constable of West Yorkshire. The aims of the law of liability in negligence are to compensate victims, deter careless behavior, and set standards of reasonable conduct. The law of liability in negligence achieves its own aims as it deters unsafe behavior by holding defendants liable for foreseeable harm, which is shown in the case of Nettleship v. Weston. However, it does not achieve its own aims as it may fail to compensate victims where foreseeability is not established, which is shown in the case of Borhill v. Young. The law of liability in negligence achieves the aims of tort law as it provides compensation and corrective justice, which is shown in the case of Donahue v. Stevenson. However, it does not achieve the aims of tort law as it can leave injured parties without a remedy due to policy limits, which is shown in the case of Hill v. Chief Constable of West Yorkshire. An advantage of the law of occupiers' liability is that it protects lawful visitors by requiring reasonable care, as shown in Wheat v. Laken. Another advantage is that it extends protection to child visitors who are less careful than adults, as shown in Glasgow Corporation v. Taylor. As well as this, occupiers' liability also allows warnings to reduce liability where appropriate, as shown in Rolls v. Nathan. However, a disadvantage of the law of occupiers' liability in negligence is that it can allow occupiers to avoid liability through warnings, as shown in Rolls v. Nathan. Another disadvantage is that it may place heavy burdens on occupiers for risks created by others, as shown in Wheat v. Laken. As well as this, occupiers' liability can also leave trespassers with limited protection, as shown in Tomlinson v. Congleton Borough Council. The law of occupiers' liability is fair as it requires occupiers to take reasonable steps to protect visitors from foreseeable risks, which is shown in the case of Wheat v. Laken. However, the law of occupiers' liability is unfair as it can deny compensation where individuals voluntarily accept obvious risks, which is shown in the case of Tomlinson v. Congleton Borough Council. The law of occupiers' liability balances competing interests as it protects visitors from harm while recognizing that occupiers should not be insurers of safety, which is shown in the case of Tomlinson v. Congleton Borough Council. However, it may not balance competing interests as it can prioritize occupier freedom over visitor safety, which is shown in the case of Rolls v. Nathan. The aims of the law of occupiers' liability are to compensate injured visitors, encourage safe premises, and limit unreasonable burdens on occupiers. The law of occupiers' liability achieves its own aims as it encourages occupiers to maintain safe environments for visitors, which is shown in the case of Glasgow Corporation v. Taylor. However, it does not achieve its own aims as it may fail to compensate injured individuals who knowingly take risks, which is shown in the case of Tomlinson v. Congleton Borough Council. The law of occupiers' liability achieves the aims of tort law as it promotes compensation and deterrence, which is shown in the case of Wheat v. Laken. However, it does not achieve the aims of tort law as it can leave injured parties without a remedy due to policy considerations, which is shown in the case of Tomlinson v. Congleton Borough Council. An advantage of the law of vicarious liability is that it ensures victims are compensated by financially secure employers as shown in Lister v. Hesley Hall Limited. Another advantage is that it encourages employers to manage and train employees properly as shown in Century Insurance v. Northern Ireland Road Transport Board. As well as this, vicarious liability also promotes fairness by placing liability on those who create risk through business activities as shown in Mohammed v. W.M. Morrison Supermarkets plc. However, a disadvantage of the law of vicarious liability is that employers may be held liable for acts they did not authorize as shown in Lister v. Hesley Hall Limited. Another disadvantage is that it can be difficult to determine whether someone is an employee or independent contractor as shown in Ready Mixed Concrete v. Minister of Pensions. As well as this, liability may be extended too far through broad interpretations of course of employment as shown in Mohammed v. W.M. Morrison Supermarkets plc. The law of vicarious liability is fair as it allows injured claimants to receive compensation from employers who are better able to pay, which is shown in the case of Lister v. Hesley Hall Limited. However, the law of vicarious liability is unfair as it can impose liability on employers for deliberate wrongdoing by employees, which is shown in the case of Mohammed v. W.M. Morrison Supermarkets plc. The law of vicarious liability balances competing interests as it compensates victims while still requiring a close connection between the employee's actions and their employment, which is shown in the case of Lister v. Hesley Hall Limited. However, it may not balance competing interests as it can prioritize claimant compensation over employer fairness, which is shown in the case of Mohammed v. W.M. Morrison Supermarkets plc. The aims of the law of vicarious liability are to compensate victims, deter unsafe practices, and distribute loss to those who create risk. The law of vicarious liability achieves its own aims as it ensures effective compensation by holding employers responsible for employee wrongdoing, which is shown in the case of Lister v. Hesley Hall Limited. However, it does not achieve its own aims as it can discourage business activity by creating excessive liability for employers, which is shown in the case of Mohammed v. W.M. Morrison Supermarkets plc. The law of vicarious liability achieves the aims of tort law as it provides compensation and deterrence, which is shown in the case of Century Insurance v. Northern Ireland Road Transport Board. However, it does not achieve the aims of tort law as it can undermine corrective justice by imposing liability without fault, which is shown in the case of Mohammed v. W.M. Morrison Supermarkets plc. The similarities between the law of liability in negligence and the law of occupiers' liability are that both are based on the duty of care, both require harm to be reasonably foreseeable, and both aim to compensate claimants for personal injury or damage caused by a breach of that duty. However, the differences are that negligence applies broadly to all relationships while occupiers' liability applies only to those controlling premises. Occupiers' liability is governed by statute while negligence is largely common law, and occupiers' liability can be satisfied by warnings whereas negligence usually cannot. The similarities between the law of liability in negligence and the law of vicarious liability are that both are part of tort law, both aim to compensate victims for harm suffered, and both involve assessing responsibility for wrongful conduct. However, the differences are that negligence is fault-based while vicarious liability can impose liability without fault, Negligence focuses on the defendant's own actions while vicarious liability focuses on the actions of another, and negligence applies to individuals and organizations while vicarious liability mainly applies to employers. The similarities between the law of occupiers' liability and the law of vicarious liability are that both can impose liability without personal fault, both aim to ensure claimants are compensated, and both place responsibility on those who control risk. However, the differences are that occupiers' liability relates to dangers on premises while vicarious liability relates to employee wrongdoing. Occupiers' liability is mainly statutory while vicarious liability is common law, and occupiers' liability depends on visitor status while vicarious liability depends on the employment relationship. Thank you for watching this video on lawmaking and the law of tort. I'll see you in the next one.